And I've just actually written an article where I've revamped that and said, you know, what is the source of the ideas that it's okay to murder Indigenous women and girls? And at the end of the day, the source of those ideas is settler colonialism and the Canadian nation state, because that system is predicated on a belief in the inferiority of Indigenous women and girls. And that inferiority has been established in multiple ways. I mean, we're called bad mothers, we are called welfare bums, we are often portrayed as drug addicts and homeless folks. But the one piece that has always been there is the hypersexualization of Indigenous women and girls and the perception that we are inherently sexually available. And that if we are inherently available sexually, then the violence that happens to our bodies doesn't count. Because, I mean, in really gross kind of pop culture terms that I've actually heard people say, we were getting what we asked for. We put ourselves in, you know, we were, by our very existence, we asked for it. And so it exonerates that violence, and that's the source of the ideas. It's this inherent belief within the settler colonial system, which is the foundation of our current Canadian nation state, that Indigenous women and girls are inferior, they're deviant, they're dysfunctional, and they need to be eliminated from this nation state. And that's what makes it okay to abuse and violate Indigenous women and girls. So to me now, I mean, education is part of that, but this, I mean, we're talking literally an entire destruction and dismantling and rearticulation of the existing Canadian nation state that would have to occur without a dependence on settler colonial domination. So that would mean things like recognizing the nationhood of Indigenous nations and honoring and respecting their rights to be self-determining and sovereign. It would mean practicing, like the Tura Wampum says, non-interference and letting our nations do what we need to do to keep our women and girls safe. And it would require, I mean, and I gotta say this again and again, it would require dealing with land. It would require either returning land or making sure we're compensated for those things. It would require undoing the Indian Act. It would require Canada to really take a step back and say, you know what? We cannot interfere in the lives of Indigenous peoples. So it's a really huge, drastic change. But until we end settler colonial domination in this country, our women and girls are at risk, because that's where the inherent belief of our inferiority originates.
And that's actually a good segue into the next document that I would like to speak with you about. It's entitled Making Space for Indigenous Feminism. It's actually a chapter in a book, and the editor was Joyce Green, but you wrote an article, or sorry, a chapter in it called The Perpetual State of Violence, an Indigenous Feminist Anti-Oppression Inquiry into Missing and Murdered Indigenous Women and Girls. And this was published in 2017, and you're the author of this, correct?
Yes, I am.
Chief Commissioner and Commissioners, I kindly ask that this be made the next exhibit. The title of the chapter is actually on the second page, not the first page of the material.
Yes, Exhibit 57 will be the article Perpetual State of Violence, an Indigenous Feminist Anti-Oppression Inquiry into Missing and Murdered Indigenous Women and Girls by Robyn Bourgeois, in the book Making Sense for Indigenous Feminism, second edition, edited by Joyce Green. I don't have a year, but I don't think it matters. Thank you.
And just for the record, the copyright is 2017, and it's Making Space.
Thank you. Exhibit 57, please.
Robyn, again, I don't plan on spending a lot of time on this material, but I do want to help set up a couple concepts for the purpose of dialogue, or when parties want to ask questions. In the chapter at page 255, you talk about an Indigenous feminist anti-oppression framework. Now, the National Inquiry has heard from a number of witnesses what Indigenous feminism is, including people like Faye Blaney, but I want to know and hope that you can help us understand what an Indigenous feminist anti-oppression framework is. And I do recognize up front that you speak about the place it starts is honoring and respecting the knowledge and experience of Indigenous women and girls, and that it recognizes the impact of colonialism and racism on the lives of Indigenous women and girls, like you've already explained to us. But what else do we need to understand about the feminist anti-oppression framework?
Sure. I think in addition to that, really, the initial grounding that we have to respect the knowledge of Indigenous women and girls, and we have to honor that, and we have to make sure that is represented in any process or any decision involving our lives. I think that's critical. There are two pieces, though, that I think are really critical to understand. The first is in terms of kind of anti-oppression and dominant systems of oppression. So when I talk about dominant systems of oppression, this is where we're talking about the isms, right? So sexism, and now, we're talking about heterosexism. We're talking about ableism, racism, colonialism, class-based divisions and hierarchy, all of those things. And I'm a student of intersectionality, or in Shireen, because Shireen was my supervisor, interlocking systems of oppression. And the idea is that my Indigenous feminist approach isn't just focused on colonialism and gender, because yes, those two things are really kind of front and center, but you have to recognize that all of the systems, whether it's class exploitation, whether it is disability and ableist privilege, whether it's race or colonialism, they all work in and through one another. So they work in mutually sustaining ways. So we can't, for example, talk about Indigenous women's experiences as just gendered experiences, because the reality is we aren't just gendered, we're racialized, but we're also defined in terms of our class, we're defined in terms of our abilities, we're defined in terms of our sexuality, and so on. And so this framework really requires that we pay attention to how all of those things work together. So you're always, and it sounds daunting, and it can be at first, but once you get in the habit of constantly thinking and exploring, what are the places where there is discrimination and oppression, and where are people experiencing privilege related to kind of these social systems, you get used to seeing it. And so this framework it's really important that we're always looking at how those multiple pieces work together to create systems of hierarchy, oppression, and violence. So that's the first piece of that. The second essential piece for me is that we always stay focused on the violence itself. I think one of the things that I have a hard time with is when we have discussions, and I just said this to my students this week, don't minimize violence. When we talk about, for example, in my class, when we talk about genocide and we talk about actual genocide under the UN Convention, and I have students then say to me, oh, it's cultural genocide, I kind of get a little upset, because that's minimizing the level of violence that Indigenous peoples have experienced under settler colonial domination here in Canada. And so this framework is really attuned. We're always paying attention to violence. Who's experiencing violence? What does that violence look like, and what is the source of that violence? So we never want to minimize or turn away from that. We never want to say focus on how. I think this is the more complicated piece. Quite often we talk about power and we talk about agency and we talk about choice, but we don't often talk about in those. There's sometimes a distancing in those discussions from the violence itself. Sometimes there's strategies that are used to say, oh no, for example, sex work is different from trafficking, for example, and that we have to keep those things distinct. But to me, they're part of a system, and we're ignoring the violence when we do that. So that's what I'm trying to draw attention to, is that we can't minimize the violence. And I think for me, I once read something from a family member of one of the missing and murdered Indigenous women and girls, and they were debating about, the discussion was about whether you tell all the kind of gruesome details about things. And this person said, you know what, I think, my family member didn't get a sanitized version of the violence. They had to live through every brutal, terrible, grotesque violent moment, and why should the rest of Canadian society get to minimize and dismiss that? And I think that's what's really important to me, is I never want us to lose sight of the violence and the fact that there are Indigenous women and girls who are being raped and murdered all across this country.
Mm. In perpetual state of violence, you talk a bit, and we've already had a bit of this conversation about the count and why the count's important. And you talk about an accurate count is not being necessary. So one of the witnesses we had in community hearings talked about he didn't care how many numbers there were. He didn't care about the statistics. He cared about the tears, how many tears were cried before women lost their lives. And I note that you talk about in this particular article that an accurate count is not necessary. And you say far too many Indigenous women and girls have gone missing or been murdered over the last few decades. And then you proceed to talk about the one RCMP report that came out in 2014. And it seems that in Canadian society, that was kind of a pinnacle moment, because the RCMP then recognized what NWAC and a number of agencies had been saying for years about missing and murdered women, that in fact that the numbers were higher than expected. But I also understand there was, from either side of the spectrum, there was real frustration that it took that report to legitimize what Indigenous women have been saying for years about there not needing to be an accurate count because one person's too many. I wanted to ask if you had anything that you wanted to talk about in terms of understanding the phenomenon of missing and murdered Indigenous women as representing just the proverbial tip of the iceberg, as you do in your article, and that really there's more to this than the statistics and numbers.
Yeah, I want to start, I think, by saying I think the position of, the numbers don't matter, but we need numbers. They're actually, I think, two sides of the same coin for me, because you know what, the bottom line is one person is enough for me. If somebody is experiencing tremendous violence, then that should be enough. We shouldn't have to make the case. Unfortunately, we live in a world, this Western colonial world, where numbers really do matter. And if you ever doubt that for a minute, just remember Stephen Harper's really decisive decision to cut NWAC's research for their database on missing and murdered Indigenous women and girls, because right there he recognized the significance of numbers and the significance of evidence in proving that there was this national phenomenon going on. So it is difficult to get accurate statistics. That's the other issue here. And that's the RCMP report is problematic. I mean, we don't talk about this a lot, but there are no kind of standards about collecting race data, for example, and there were periods where police weren't encouraged to collect race data because that might enact racism, but then they started collecting race-based data in order to show racism. And without those standards, I mean, we don't even know for sure how accurate the RCMP numbers are. And I'd be way more inclined to believe the communities and the activists who have been arguing that those numbers are much, much higher. 3,000, for example, is a number that's often been shared. And I think that's probably way more accurate, because I think there are a lot of cases that have gone unrecognized as missing and murdered Indigenous women and girls. We don't know how accurate police files are. And we also know that RCMP have a tendency to refuse cases involving Indigenous women and girls. So that's a huge issue. And yet the numbers also help make cases. So it's really a complicated issue. I do want to say directly, Krista, to your two questions. First of all, these numbers are the proverbial tip of the iceberg. I have to remind my students this continuously. They often say, here's this contemporary phenomenon of missing and murdered Indigenous women and girls. Well, you know what? Yes, we've been focused on this from 1980 forward, is the context that is prominently given. But this phenomenon of violence against Indigenous women has gone back throughout colonial history. We've always had missing and murdered Indigenous women and girls. It's just that we're now paying attention to it in this kind of contemporary context of 1980 forward. But it's also really important to recognize that that is just one piece of the puzzle, that Indigenous women and girls experience extraordinary rates of all forms of violence. There are numbers, in terms of sexual violence, for example, that 75% of our young women won't reach the age of 18 without experiencing some form of sexual abuse. We know that, there's the very famous ONWA study, the Ontario Native Women's Association study from the 80s that found that 8 out of 10 Indigenous women experience some form of violence in their homes. We know that again and again, it's not just about missing and murdered Indigenous women and girls. If we look at sexual violence, if we look at sexual exploitation, if we look at structural forms of violence, we can see that Indigenous women are grossly and disproportionately impacted by all forms of violence. It doesn't matter, it really does not matter. If we look at those, and the stunning thing is when you look across, we see that, it's in every category that Indigenous women and girls are experiencing these higher rates than non-Indigenous women and girls in this country. And I think that's really important for people to understand that the missing and murdered is a really important focal point, but it really is, there is a much bigger picture, and it is, this is a web of violence that has made this possible.
My last question in relation to the perpetual state of violence is how you contextualize the justice system and label it as the injustice system. Specifically at page 265, you talk about the Canadian legal system having the long history of failing to protect Indigenous women and girls from violence while simultaneously exonerating perpetrators and erasing the violence. Thanks largely to the sexualization and racialized discourses of inferior and degenerate Indigenous femininity. You also talk about how prostitution, and you told us this earlier when you were first talking about your studies, prostitution is a justification for minimizing the violence. Can you tell us a little bit more about the injustice system and this in particular perpetuating or using prostitution as a justification for minimizing violence?
Absolutely. So I call this the Canadian injustice system because what we see is that again and again, first of all, if there is ever charges laid, because we know, and the Missing Women Commission Inquiry made this really clear, that oftentimes, even at the police level, there's decisions made not to press charges or not to investigate or to dismiss the violence as, or erase the violence actually by categorizing a death, for example, as misadventure or an accident, when in fact that there is clear evidence that it was likely a homicide or something more sinister. And I think that's a problem. But when it gets to the courts, even if that's the case and people are charged and brought to the court system, what we see is that again and again and again and again and again, our Canadian courts, they rely heavily on the hypersexualization of Indigenous women and girls to not only erase the violence, because they'll erase it by saying, oh, you know what, she consented to this, or she, was engaged in prostitution, or, she, was drunk and promiscuous, or any of those things. I mean, I've heard it again and again in different court cases, but those are used to minimize the violence. So, it wasn't violence. And it flips the other way too, because it's not just about portraying Indigenous women and girls as deviant, but it flips the other way. And quite often the perpetrators are portrayed as, good white folks, because it's often good white men who make a bad mistake and made a bad choice, or they were good guys who just made a bad choice, which is problematic. And so what happens within the systems, we see again and again, that perpetrators aren't held accountable, that they're often given lenient sentences if they're sentenced at all. And that is often, that decision is often made on this kind of belief about the victim herself, an Indigenous woman or a girl. They always are coming up with different ways to show, why an Indigenous woman or a girl is not a worthy victim who is worthwhile and deserving of justice within the Canadian legal system. And one of the things I've noticed, and I shouldn't say just me, because I think there are other people who have documented this as well, and I draw on some of this in my work. But one of the things I've noticed is that prostitution has played a really key role in this process again and again and again. And what we see is, even from very early times and early colonial settlement here in Canada, is that within the justice system, that prostitution and Indigenous women's either perceived, and that's important because perceived or actual involvement in the sex trade and prostitution has served as justification of the violence and has served to exonerate perpetrators. And it happens again and again and again. And it not only happens in individual cases, but what I've noticed is that the Canadian state uses prostitution as well as a justification for not taking action. So this is something I've been writing about really heavily in terms of the missing women from Vancouver, is that if we look at the explanation that's given in the Missing Women Commission of Inquiry, for example, again and again we come up to this fact that the police justified their inaction again and again and again by saying, oh, these women were involved in prostitution. And so that's a concern for me, because what I'm seeing is that prostitution is kind of this kind of get out of jail free card. And if you can prove a link, whether perceived or actual, between an Indigenous woman who's experienced, or a girl who's experienced a tremendous act of violence, and you can link that in any way to prostitution or hypersexuality, then perpetrators get either reduced sentences or completely exonerated. And that's a huge issue because, you know, it's not just about perpetrators, the state is using this as well. I mean, this is what the excuse was with the missing women. Why didn't police investigate? Why did it take, you know, almost 20 years before they took this seriously? It was because of this belief that these women were entrenched in the sex trade, and for that reason, you know, they weren't likely victims. And so it allows for general inaction on violence against Indigenous women and girls, and that's a huge concern for me.
And so would you agree with me that this reliance, whether it's perceived or real, the characterization of women being involved in sex work is resulted in them being seen by courts, the system, and government as less than worthy victims?
Absolutely. And not only that, I'd say the media and mainstream Canadian society. I mean, that's, you know, if you look at the media discussions of the missing women, that's what the scholars have pointed out is again and again, the dominant perception advanced by the media is that we are hypersexualized and involved in prostitution. And general society also shares these perspectives. You know, whenever I talk to groups of people about what they believe or what they know about Indigenous women and girls, that's one of the first things that it always comes up. You know, they're you know, involved heavily in prostitution, or, you know, there's mention of the squaw and that hypersexualized Indigenous female who is inherently sexually available. And, you know, so it's everybody's perception, but, you know, the mechanisms of justice, that's a huge foundational piece there.
Mm. If I could get you to turn your attention to another article that you've written that was in the UCLA Law Review. It's called Colonial Exploitation, the Canadian State and the Trafficking of Indigenous Women and Girls in Canada. Now, this article already touches on some of the fundamental concepts that we've discussed and that you had in other articles. So I really want to kind of focus down a couple key thoughts on this one. But just first, for the purpose of the record, you are the author of this article.
Yes.
Chief Commissioner, Commissioners, may I have this marked as the next exhibit, please?
Yes, Exhibit 58 is Colonial Exploitation, the Canadian State and the Trafficking of Indigenous Women and Girls in Canada by Robyn Bourgeois, UCLA Law Review, 2015.
So in sort of following through some of the concepts that you've explained to us and some of the theories that you support in terms of, you know, and taking as base principles the concepts of colonialization, What I'm really hoping to focus on in this particular article is the state action or inaction, particularly as it relates to international issues. And so we have had a one hearing week where we focused specifically on human rights. We talked about a number of conventions and in terms of how they apply. And I know in this article you actually focus on some of Canada's obligations as signatory to particular instruments. So I'm wondering if you can give us first a little bit of background about particularly framing human trafficking, looking at the Canadian state definitions and conceptualizations of human trafficking as you did in your article.
Okay. And I'm going to just draw my notes because it's been a while since I wrote this article. And sometimes my memory isn't so great. I have to say that this article came out because I was asked to talk as part of a panel on human trafficking. And I was like, okay, I've got to prepare for this. And I was thinking about, how has the state defined this? And so I went digging to see, what was going on. And I started noting, first of all, the first thing is that really human trafficking as an offense really doesn't originate in Canada until the 2000s. So the first kind of piece of legislation that Canada is a signatory to is not even a national piece of legislation, it's international. And it's what is commonly referred to as the Palermo Protocol. And the actual full title for that is the UN Protocol to Prevent, Suppress, and Punish Trafficking in Persons. And that was brought in 2000, and Canada is a signatory on that international agreement. And it really is kind of the starting point for the definition, the Canadian definition of human trafficking. And it draws attention to a few things. So the definition within Palermo deals with human trafficking as being about recruitment, transportation, transferring, harboring, or receipt of a person by means of threat or coercion or other use of force. And that can include things like coercion, abduction, fraud, deception. And one thing that I think is really important is any other form of abuse of power. So I think that's a really critical piece when we talk about the Canadian state, because it talks about abusing a position of power and putting somebody in a position of vulnerability, I think is really important. And it also in that Palermo definition says that trafficking is also related to giving or receiving payment or benefits to achieve the consent of a person to be able to control or exploit another person. And one of the things that's really interesting is how this protocol determines exploitation, because it's one of the first times where we see, what does exploitation mean in terms of human trafficking? And the protocol here really refers to the very first piece is exploitation of the prostitution of, let me get the wording of this right. The protocol is exploiting the prostitution of others and of other forms of sexual exploitation. It can include also forced labor, slavery, other versions of servitude, and also deals with the removal of organs. And there's some really key things. And I mean, when I was trying to build this article, I was trying to make the case for showing that Canada has actually engaged in human trafficking. So I was really interested in a few protocols that Canada is bound to under those obligations of the Palermo Protocol. I was interested in, for example, that they have to offer protection to people who might be trafficked. They have to ensure that there's anonymity and privacy in whatever kind of institutions or mechanisms for prosecuting or addressing human trafficking. You have to be sure that you include the perspectives of survivors whenever you're dealing with prosecution or any kind of response to human trafficking. That you have to be sure that you implement measures to limit harm and that you really need to take care of not just physical harm, but psychological harm and social harm as well. And that you have to consider in human trafficking, you always need to consider the social factors. So human trafficking under the Palermo Protocol can't just be about paying attention to, who's being trafficked. It has to pay attention to things like gender and race and class and age and other factors that make certain social groups vulnerable to trafficking. The other thing that I think is really important, and it's from Article 6, subsection 5 of the protocol that I think is really important, is that all the signatories must agree to protect survivors while they're within their territorial boundaries. So Canada has an obligation to protect people from human trafficking. So that is really the start of the Canadian definition. And it really isn't until 2002 that Canada starts implementing its own kind of policies around human trafficking, right? So in 2002, there is provisions made through the Immigration and Refugee Protection Act, which is interesting because the first approach is that it's an international issue. And so the first focus of the Canadian government isn't on trafficking within Canada, but it's really looking at it's really focused on people bringing people from other countries into Canada to be trafficked. And that's a huge issue because, as we know, Canada has a huge internal and domestic sex trafficking industry. And so the external focus really created some issues because for a long time, that's what people really focused on. And there was concern and attention paid to bringing people into Canada for sexual exploitation. Well, the trafficking of people within the borders wasn't being looked at. And that, really, again, that piece of legislation was really focused on criminalizing transportation of bodies into Canada for the purposes of exploitation, including sex trafficking and organs and things like that. And then Canada decides, okay, we're going to take this domestically. It takes a couple of years, but 2005, the provisions are then added to the criminal code, and it comes in kind of consecutive pieces. So in 2005, trafficking is made a crime in Canada. It's the first time. Sometimes I think that's just such a stunning thing. I can't fathom that it wasn't. I mean, it's only been 13 years since human trafficking has actually been a criminal offense in this country. I think that's stunning to me. And then in 2010, it was amended to add increased penalty for people under age 18. And then in 2012, they implemented provisions that allowed for the prosecution of Canadians who were engaging in trafficking outside of Canada. So there's some really important things that happen here in these definitions. And things that are really kind of bizarre, actually. Canada has a really bizarre situation when it comes to this. So like Palermo, Canada's definition talks about recruitment, transportation, transferring of people, receiving, holding people, concealing people, harboring people for the purposes of exploitation. But it also says exercising control, direction, or influence over the movements of people for the purposes of exploiting them or facilitating their exploitation. I think that's an interesting definition because that's the one that caught my eye and went, oh, wait a second, the government of Canada has done this a lot in regards to Indigenous peoples, and I went after that. But there are some really interesting things I think that are pointed out about these provisions that I think is worth the Commission needs to hear. And the first is that whether it be the Criminal Code or the Immigration and Refugee Protection Act, both people who are considered nationals within Canada, but also people who are international, are protected against human trafficking. Those provisions are in place. Now, there is a common belief that transportation is a requirement, and Canada doesn't actually stipulate that in its laws. So you don't actually have to move people because there is sometimes the belief that that has to happen for it to be trafficking, but in reality, that isn't the requirement. It is part of it, but it is not a requirement. The thing that is really bizarre about Canada, and I think is probably the most problematic piece of human trafficking legislation. And Canada, as far as we know, is the only country that does this. But Canada requires that victims of trafficking be able to prove that they experienced fear in order for the case to be valid. So there is onus on victims to prove that they either feared for their own lives or they feared for the lives of others, like family members, for example. And that was kind of the source of exploitation. That became kind of a point where they could, where they were exploited. And I think that's really problematic. We're the only country in the world that demands that victims prove they experienced fear. And why that's hugely problematic is because if you look at the issues of the sex trade and, trafficking for sure, but I would say this extends to survival sex work and sex work. I think it's all aspects of it. Fear isn't always clear. There is so much complexity in the relationships. And sometimes, for example, people who are trafficked are often trafficked by intimate partners or people who they believe are intimate partners or family members or people that they knew. And so it gets murky because, this is the situation that happened for me. You're told this person loves you and they're your boyfriend and they're going to take care of you. And then they're forcing you to do things that you don't want to do and they're exploiting you. And how do you establish fear there? Because maybe there was fear, but I also love this person and I was just trying to make this person, it's really complicated. And so to then put the onus on victims to prove that they experienced fear is really problematic, and it's certainly not trauma informed. This really relates back to the kind of broader debate we're having in Canadian society and actually the world right now about believing survivors. That survivors of sexual violence, we're often asked to prove that we've been violated and we're not believed. And that's what this protocol does for human trafficking. It says we have to prove fear. I think the final thing that's really important is that in terms of human trafficking law, Canada nullifies consent as an argument. So people who are accused of trafficking can't say that the person consented to being trafficked. And I think that's really important because, consent is being hugely debated right now in Canada in response to the case of Cindy Gladue. And I think it's really important that this be in place here in human trafficking laws, because there are people who would make the case that, this person actually did consent to me exploiting them.
Thank you, Robyn. There's one more point in relation to this, and thank you for laying out what you believe are the important focuses of understanding the Palmer Protocol as well as the Canadian law. One of the arguments that you make on page 1437, looking at the academic research in the area, you talk about how the criminal code definitions also of human trafficking centers not just on the fear for safety, but also sometimes there's a fail to criminalize because there's a belief that harm has to be demonstrated and that the harm has to be physical. You cite that it could be argued that safety should not be restricted simply to the physical harm, but also should encompass psychological and emotional harm. And that's taking, and that is, you've talked about this before in terms of the concept of safety. So what is the problem with only looking at physical harm instead of recognizing the psychological or emotional harm that occurs from trafficking?
For sure. This comes back to kind of an Indigenous way of knowing and doing, is that we understand a holistic understanding of who we are as people, right? So we are not only physical in our manifestation in our bodies, but we are also spiritual beings. We have psychological things, we have emotional well-being. And when we focus just on the physical aspects of harm, we're missing the bigger picture. Because one of the things, and I've had some discussions lately about people or with people about this, who are either survivors or people who have who work with people who have been trafficked. And one of the things that is overwhelming is the psychological and the emotional and the spiritual harm of this. And in fact, oftentimes the physical harm can be, it doesn't go away, but it can be minimized. Like you eventually heal some of those things, but the psychological and the emotional and the spiritual hang on until forever. Even to this day, I'll tell you, in preparing for this testimony, I had those internal battles about, am I ready to share my story on this huge national stage? Am I ready to, expose myself in that way? Because again, the messages are in my head, oh man, people are going to be like, there's that, former, sex trade person, she was, trafficked, but, she's still like dirty and unreliable and disgusting and all of those things. And, I still deal with the issues, the psychological issues, a lot more than I deal with some of the physical things. I have PTSD and my symptoms, I've had some good length of time to work on those, and I've had privilege to be able to do that, because I will say that the systems weren't great at helping me, and the only way I could access some of those things was because my mom found the resources to get me help a lot of the time. And those things never go away. I still deal with those. I still have panic attacks. I still jump when I hear a phone ring. I have a really hard time being in confined spaces because of some of the things that were done to me. I have really tough relationships with men because I was predominantly abused by men. And it's tough. And so to focus on the physical harm minimizes the scope of violence when it comes to human trafficking, because it is so much more. It is coercion, it is manipulation, it is taking somebody and breaking them down. In fact, that's what I've often heard of the process described as. The kind of process of grooming, I've also heard be referred to as breaking down. You're breaking somebody in. And part of that is physical. There is certainly a lot of use of sexual violence and physical violence, but a lot of it is psychological, and it's emotional, and it's spiritual. It's, attacks on your character. It's being told that you are worthless and nobody will ever love you again, and that you are not worthy of even basic kindness. Little things like not hearing your name for weeks on end because you're not even given a name. Those things stick with you. And so I really think, we're missing a big part of the picture if we don't pay attention to the bigger pieces of that as well, and recognize that the harm isn't just physical, it is all of those things.
Thank you. I just wanted to touch on briefly, in this article, you had said earlier, I was making the case that Canada's trafficking. And one of the cases you're making is the trafficking of Indigenous children by using the example of the Indian residential school. And it's interesting because you point out in your article that if we take the Canadian definition or the Palmer protocol definition of human trafficking, that the IRS actually fits that definition. And I just want to point that is out at 1461 through to 1426. And are you okay answering questions? I'm not going to explore it with you right now, but are you okay answering any questions in relation to that assertion you're making by any of the parties withstanding?
Absolutely.
Thank you.
And I would extend it. I would say it's not just the residential school. I would say it has continued to be manifested in the apprehensions of our children through the child welfare system. So it's a bigger picture too as well, but I'm happy to answer questions about that.
You anticipated which was going to be my next part of the question. So thank you for that. I noticed that in your conclusion, you say the Canadian state has to take a hard look at itself and examine its complicity in this violence, and that ending the trafficking of Indigenous women and girls will not only require addressing how Canadian state is complicit in this violence, but require the dismantling. And that's kind of where you started. So you'd agree with me, you believe we can take small steps, but it's in order to have the actual change, it's going to be a large dismantling of the colonial domination?
Yes.
And I know that you provided us actually with particular recommendations that you're making. This is in Schedule E for any of the parties withstanding or for the commissioners to look at. And I know that we've actually kind of already contextualized and situated some of these well. This you prepared for, particularly for the National Inquiry, I understand, right?
Yes, I did.
Yes, and there's a number of recommendations. You actually have, I believe, 10 of them listed. And given, and I never like to rush anyone, but given the time frame we have, I'm going to ask if you can give some highlights. But before I do that, I'm going to ask that the Chief Commissioner and Commissioner accept these recommendations as the next exhibit.
Okay. Yes. Exhibit 59 is recommendations, sexual exploitation, human trafficking, and sexual violence, prepared by Dr. Robyn Bourgeois, October 2018.
And Robyn, is there, and you'd be happy to answer, would you be okay or happy to answer any questions the parties might have in relation to these recommendations you're submitting to in cross-examination?
Yes.
Okay. And on that basis, though, I want to afford you, 5 or 6 minutes to highlight for the commissioners these recommendations.
Sure. I would highlight the first. We have to decolonize this country. We really have to look at Canada's complicity in violence against Indigenous women and girls, and we have to decolonize, because I said this earlier, the source of the idea that it's okay to sexually exploit Indigenous women and girls is settler colonialism and its heteropatriarchal beliefs about the hypersexuality of Indigenous women and girls. And so the system is predicated on that. So the only way we're going to challenge that is we have to dismantle the system, and it's going to be huge. It will be, I've listed some really particular strategies within those recommendations, but it's going to have to include things like dealing with land and either returning it or recompensating us, or it will be not offering these kind of governmental rooted self-government agreements, but truly and honestly recognizing and respecting Indigenous self-determination and sovereignty. It's going to have to require things like returning our children to us out of the child welfare system, because it's time for our communities to take care of ourselves. So that is really the key thing, is that Canada is going to have to take a really hard look at its own complicity in the system of violence and exploitation, and a lot of decolonization and not reconciliation. I have a real problem with reconciliation because it seems to be about inclusion of Indigenous culture, but it doesn't seem so much about really dealing with the things that matter, like land, like Indigenous self-determination, like ensuring the safety and security of Indigenous women and girls across the country. So it will be serious. The other thing, as far as things go now in terms of sex trafficking and the sex trade, I make kind of 3 arguments that I think are important. The first is that I think we should, we've already got exemptions under the criminal code for the different pieces of prostitution that are criminalized, so that if somebody is selling themselves, that they are exempt from prosecution. And that is to all pieces of that except for one, and that is communication. Communication is still criminalized, and I really think we need to decriminalize that. And I understand that that was put in place because if we're going to abolish the sex trade, we have to denaturalize all parts of it, and we need to kind of end that. But the problem is for me that if as I do understand the sex trade as predominantly being a system of violence and oppression, then I could never in my heart of hearts be okay with criminalizing someone who has to sell their body and their sexual services. I think that is, I don't want to get into morality, but for me, that's immoral to who I am and my understanding of the world and of violence. But I also think it is a really dangerous thing when we start to criminalize the bodies of people who sell sex. We end up creating situations where the Canadian state in particular can be justified in inaction, and we've seen that again and again. So I really argue for the decriminalization of all those aspects in relation to people who are selling their own sexual services. That being said, I argue that we should continue to criminalize pimping and trafficking as we do, with a caveat though, because those laws are often unfairly applied to people involved in the sex trade, for example. So I've heard incidents